power. Information is liberating. Education is the premise of progress in every society, in every family. Quote by Kofi Annan. A very good evening, ladies and gentlemen. Welcome to the Karnataka State Bar Council Law Academy online lecture series. I, Varsha R., a student of University Law College and Department of Studies in Law, Bangalore University, extend my humble salutations to all the distinguished guests, hosting committee, and participants who have gathered virtually here today. It's indeed a privilege to have with us Hon'ble Justice N.Kumar, retired judge of High Court of Karnataka, who will be delivering lecture regarding Civil Procedure Code 1908. Now, I request Sri Gautam Chand SF, President of Karnataka State Bar Council Law Academy, to formally commence the program. Over to you, sir.
Eldrigu namaskara. A very good evening to one and all. Before we proceed with the lecture series, may I request Mr. Anil Kumar JM, the chairman of KSBC, to deliver welcome address. Over to you, Mr. Chairman.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರಗಳು. ಈ ಒಂದು ವಿಶೇಷ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ನಮ್ಮೊಂದಿಗೆ ಉಪಸ್ಥಿತಿ ಇದ್ದು ಇಂದಿನ ಉಪನ್ಯಾಸವನ್ನು ನೀಡಲಿಕ್ಕೆ ನಮ್ಮೊಂದಿಗೆ ಇರ್ತಕ್ಕಂಥ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದಂಥ ಎನ್ ಕುಮಾರ್ ಸಾಹೇಬ್ರವರೇ, ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಉಪಾಧ್ಯಕ್ಷರಾಗಿರ್ತಕ್ಕಂಥ ಎನ್ ಶಿವಕುಮಾರ್ ಅವರೇ, ಬಾರ್ ಕೌನ್ಸಿಲ್ ಆಫ್ ಇಂಡಿಯಾದ ಸದಸ್ಯರಾಗಿರ್ತಕ್ಕಂಥ ಮಾನ್ಯ ಸದಾಶಿವ ರೆಡ್ಡಿ ಅವರೇ, ಲಾ ಅಕಾಡೆಮಿಯ ಅಧ್ಯಕ್ಷರಾಗಿರ್ತಕ್ಕಂಥ ಮಾನ್ಯ ಶ್ರೀ ಗೌತಮ್ ಚಂದ್ರ ಅವರೇ, ಹಾಗೂ ಬಾರ್ ಕೌನ್ಸಿಲ್ನ ಎಲ್ಲ ಗೌರವಾನ್ವಿತ ಸದಸ್ಯರೇ, ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗಿಯಾಗಿರ್ತಕ್ಕಂಥ ಎಲ್ಲ ವಕೀಲ ಮಿತ್ರರೇ, ಉಪನ್ಯಾಸಕರೇ, ವಿದ್ಯಾರ್ಥಿಗಳೇ ಹಾಗೂ ನನ್ನ ಸಹೋದರ ಸಹೋದರಿ, ಇವತ್ತು ಈ ಏನು ಕಾರ್ಯಕ್ರಮವನ್ನ ನಮ್ಮ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಲಾ ಅಕಾಡೆಮಿ ಹಮ್ಮಿಕೊಂಡಿದೆ, ಇದೊಂದು ವಿಶೇಷವಾಗಿರ್ತಕ್ಕಂಥ ಕಾರ್ಯಕ್ರಮ. ಹಾಗೂ ನಾವು ವಿಶೇಷವಾಗಿ ಈ ಕಾರ್ಯಕ್ರಮವನ್ನ ವಕೀಲರ ಜ್ಞಾನಾಭಿವೃದ್ಧಿಗಾಗಿ ಮತ್ತು ಈ ಪರೀಕ್ಷಾರ್ಥಿಗಳಿಗಾಗಿ ಹಮ್ಮಿಕೊಂಡಿರ್ತಕ್ಕಂಥ ಕಾರ್ಯಕ್ರಮ. ಇಂತಹ ಕಾರ್ಯಕ್ರಮದ ಸ್ಫೂರ್ತಿ ನಿಜವಾಗಿಯೂ ಎನ್ ಕುಮಾರ್ ಸಾಹೇಬರು. ಅವರು ನಮ್ಮ ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಜುಡಿಷಿಯಲ್ ಅಕಾಡೆಮಿ ಅಧ್ಯಕ್ಷರಾಗಿದ್ದಾಗ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿಗೆ ಎನ್ರೋಲ್ ಆಗಿರ್ತಕ್ಕಂಥ ಅದಾಗ ತಾನೇ ಎನ್ರೋಲ್ ಆಗಿರ್ತಕ್ಕಂಥ ವಕೀಲರಿಗೆ ಒಂದು ಟ್ರೈನಿಂಗ್ ಪ್ರೋಗ್ರಾಮ್ ಮಾಡಬೇಕು ಅನ್ನುವಂಥ ಒಂದು ಸಲಹೆಯನ್ನ ನೀಡಿದ್ರು. ಅದೇ ರೀತಿ ಅಲ್ಲಿ ನಾವು ಕಾರ್ಯಕ್ರಮವನ್ನ ಹಮ್ಮಿಕೊಳ್ಳಲಿಕ್ಕೆ ಸಾಧ್ಯ ಆಯಿತು. ಅದು ಸತತವಾಗಿ ಹಾಗೇನೆ ನಡೆದುಕೊಂಡು ಬರ್ತಾ ಇದೆ. ಅಂತಹ ಒಂದು ಸ್ಫೂರ್ತಿ ಹಾಗೂ ನಮ್ಮೆಲ್ಲರ ಹಿರಿಯರು ಆಗಿರ್ತಕ್ಕಂಥ ಎನ್ ಕುಮಾರ್ ಸಾಹೇಬರು ಇವತ್ತು ಈ ವಿಶೇಷ ಉಪನ್ಯಾಸ ಮಾಲೆಯ ಪ್ರಥಮ ಉಪನ್ಯಾಸವನ್ನ ಇವತ್ತು ನೀಡಲಿಕ್ಕೆ ನಮ್ಮೊಂದಿಗೆ ಇದ್ದಾರೆ. ಅವರನ್ನ ಈ ಸಂದರ್ಭದಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಪರವಾಗಿ ಹಾಗೂ ರಾಜ್ಯದ ಎಲ್ಲ ವಕೀಲರ ಪರವಾಗಿ ಅವರಿಗೆ ಸ್ವಾಗತವನ್ನ ಕೋರ್ತಾ ಇದ್ದೇನೆ. ಈ ಒಂದು ಸಂದರ್ಭದಲ್ಲಿ ನಮ್ಮೊಂದಿಗೆ ಈ ಒಂದು ಆನ್ಲೈನ್ ಉಪನ್ಯಾಸ ಮಾಲೆಯಲ್ಲಿ ಪ್ಲಾಟ್ಫಾರ್ಮ್ನಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಎಲ್ಲ ಮಹನೀಯರಿಗೆ ನಾನು ಈ ಸಂದರ್ಭದಲ್ಲಿ ಸ್ವಾಗತವನ್ನ ಕೋರ್ತಾ, ಈ ಒಂದು ಕಾರ್ಯಕ್ರಮದ ಯಶಸ್ಸಿಗೆ ತಾವೆಲ್ಲರೂ ಭಾಗಿಯಾಗಿರ್ತೀರಾ. ಮುಂದಿನ ದಿನಗಳಲ್ಲೂ ಕೂಡ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಇದೇ ರೀತಿಯಾದಂಥ ತಮ್ಮ ಸಹಕಾರ ಇರಲಿ ಅಂತ ಆಶಿಸ್ತಾ ನನ್ನ ಈ ಸ್ವಾಗತ ಭಾಷಣವನ್ನು ಮುಗಿಸ್ತೇನೆ. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ.
Thank you, Mr. Chairman. Though no formal introduction is required for Honorable Justice N. Kumar, all of us know him very well. Still, in order to refresh our memories and to make young advocates and students understand what he is, may I request Mr. Vinay Manglekar, the trustee of Karnataka Law Academy and member Karnataka State Bar Council, to kindly speak a few words and introduce Justice N. Kumar. Over to you, Mr. Vinay.
It's my privilege and honor to introduce to you all today's resource person, Honorable Justice, Mr. Justice N. Kumar. Honorable Justice N. Kumar was born on 28/6/1954 at Chikbalapur village in Chikbalapur district. However, he hails from Hosur village, Gauribidnur Taluka, which is also at Chikbalapur district. He had his formal education in Bangalore, graduated from Vijaya College, obtained law degree from Renukachari Law College and a master's degree in political science from Karnataka University. He enrolled as an advocate in 6/2/1976 and started his practice as a junior of Sri L.S. Varadaraj Iyengar, a leading practitioner on the civil side. On 18/1/1991, he started a law firm under the name and style of Kumar and Kumar, along with his friend Sri C.S. Prasanna Kumar. He had extensive practice on the original side and extended the practice to the High Court. In all, 25 years at the bar, specializing in civil matters, company law, labor and constitutional matters, which are his specialized fields. He served in various institutions as legal advisor. He was also assistant editor of Indian Law Reports, Karnataka, for a period of 6 years. He was subsequently elevated as judge of High Court of Karnataka on the 11th December 2000. He was judge of the High Court of Karnataka for 16.5 years. As a sitting judge, he has had the opportunity of hearing constitutional, company, labor, service, and civil matters. He is actively involved in training judicial officers of the state of Karnataka in the Judicial Academy. He was also the president of the Karnataka Judicial Academy for a period of 4 years. Honorable Mr. Justice N.Kumar was also the executive chairman of International Center for Alternate Dispute Resolution, Bangalore chapter, and was involved in promoting arbitration, mediation, and conciliation as an alternative mode of resolution of disputes. He participated in the Judges' Roundtable on the role of judiciary in IPR development and adjudication held at National Judicial Academy, Bhopal, India. He participated in IPR Summit 2006 International Conference on IPR held at Bangalore by US India Business Council and was a panelist in the session on an insight in IP infringement, perspective of judiciary from the High Court, and recent patent law activity in the US, UK, Germany, and India. He has delivered keynote addresses in the state level seminars organized by Human Resource Department, Government of India on the subjects such as perspective in intellectual property rights and patent law and its prospects on drug development and disease prevention strategy. He was conferred the honorary doctorate in law by the Alliance University on 18/12/2015. At present, he is chairperson, professor of human rights in the National Law School of India, University, Bangalore. He was chairman of International Commission of Jurists, Bangalore chapter in the year 2018-19. He was awarded the Karnataka Rajyotsava Award by the state of Karnataka for his contribution in the legal field in 2019. On a personal front, Justice Kumar is married to Srimati Geeta and has 2 children, Preeti and Niti. His love for the profession and the institution can be gauged from the fact that his wife and both his children are lawyers. I hope everyone watching this lecture series will immensely benefit from the knowledge of Honorable Justice N.Kumar. Thank you very much.
Thank you, sir. Before we get started, any questions on the lecture can be posted to Professor Dr. V. Sudesh, who is the co-host in Zoom. And if you're watching this on YouTube, kindly post the questions in the comments and we will be taking up during the question and answer session towards the end of the program. Code of Civil Procedure was enacted to bring uniformity of procedure amongst the courts of civil judicature. To analyze, discuss, and enlighten us on the topic, with proud privilege, I welcome our exemplary dignitary, Hon'ble Justice N.Kumar, retired Judge of High Court of Karnataka. Over to you, sir.
Good evening to all of you. ತಡವಾದರೂ ತಮ್ಮೆಲ್ಲರಿಗೂ 65ನೇ ಕನ್ನಡ ರಾಜ್ಯೋತ್ಸವದ ಶುಭಾಶಯಗಳು. I am glad to be a part of this program organized by Karnataka State Bar Council for the benefit of younger members of the bar and students who intend entering the legal profession in future. Before I take you the relevant provisions of the Civil Procedure Code, I want you to know the importance of the Civil Procedure Code and also the system in which we are working and what is expected of you. Access to justice is now a fundamental right under the constitutional scheme of this country. Mark the words, access to justice, not access to courts. That means first you should enter the court. In the court, you must get justice expeditiously. Keeping this in mind, throughout the country and in particular Karnataka, today we have courts in each taluk, and in some cases, even in Hoblis, courts are established. The whole object is the judicial administration should go to the doors of the litigant, not the other way around. Mere establishment of courts in rural area, in taluks, Hoblis is not sufficient. That should cater to the requirement of the litigant public, and justice should be done. And therefore, it was also held speedy trial and justice is also a fundamental right. So every law student, every lawyer should bear this aspect in mind when he thinks about the legal profession. Access to justice is a fundamental right. Speedy trial is also a fundamental right, and it should be the endeavor of every person who are in this legal field to see that this constitutional goal is achieved and the litigant public gets what is legitimately due to him. Now, in this context, there is a criticism of the Indian judicial system, not only outside the country, but also inside the country. What is the criticism? The Indian judicial system, there is an inordinate delay in disposal of both criminal and civil cases. Insofar as civil cases are concerned, the argument is that the Civil Procedure Code is the cause. Civil Procedure Code is the procedural law of the land. This is the vehicle through which the rights of the parties are agitated and justice is done. But this Civil Procedure Code is the cause for delay in disposal of cases. Please remember, this is an enactment passed in the year 1908, prior to our independence. Now 73 years are over after independence. If really Civil Procedure Code is the cause for delay, in these 73 years, we are not able to have a procedural law suited to this country. We are still following the Civil Procedure Code. Therefore, it can be safely said there is no substance in the said allegation. However, believing these criticisms, both inside and outside the country, the lawmakers, the parliament, amended the Civil Procedure Code in the year 1976, exhaustive amendments. That was not sufficient. Therefore, it was exhaustively amended in 1989. Again, it was amended in 2002, and recently in 2015, exhaustive amendments were carried out. If really the Civil Procedure Code was the cause, as enacted in 1908, and if these amendments enable speedy disposal, the lawmakers, the law parliament has done their job. No, nobody can have any grievance against them. If still delay persists, one cannot blame the Civil Procedure Code or the law. Please remember that. Whatever you said is accepted. Parliament has done its job. Amendments, extensive amendments are brought. Now the question is whether with all this, the delay is managed or is curtailed. In fact, it is the judges and lawyers also believe that CPC is the cause of delay. Now, in this background, what I would like to tell the younger members of the bar and the future lawyers, the students, is please remember, now you are all in the 21st century. All of you had the fortune of studying law in a professional course for 5 years, which was not the position about 30 years back. I have no doubt in my mind that the present generation are all more intelligent than the previous generations. You have a good command over English language. You are exposed to the happening of the world, which you can observe sitting in your house through internet, smartphones, YouTube, Facebook, WhatsApp, Instagram, Twitter, Skype, etc. All of which were not available to the previous generation of lawyers. Therefore, your knowledge in almost all spheres is certainly far superior to that of the previous generation. I am sure, in view of the aforesaid influences, you are impatient. You want things to move fast, and certainly you would not like the delay. Now that you have chosen this legal profession, and you want to be part of this litigation process, it is natural that you want speedy justice and the results expeditiously in a court of law. Otherwise, probably you will be disappointed. Now, as lawyers and judges, for everything we look backwards. Why? We believe in what is known as the law of precedence. And virtually we have become slaves of the past. Any problem, we look back and see whether any court has decided such a matter, so that we can simply apply that and say, I have done my job. Therefore, we refuse to think forward, because that is what we are told. And that is the training which we undergo. For every problem, if you have to look into the digest, and we have case law for 100 years and 150 years from Indian law reports, Chancellery Division, Privy Council, Supreme Court cases, and now that technology has advanced, with a touch in the mouse, you will get case law. So the whole object is to look backwards to find a solution to the present day. But we must realize the society is changing fast, and the law to be useful and meaningful, it has to keep pace with the changing of times. It is in this background we have to see whether the procedural law of the land, as amended from time to time, is not suited to delivering speedy justice to the litigant public. That is the criticism. Now, in my opinion, there is nothing wrong with the Civil Procedure Code, which is drafted in 1908. Even without the amendments, it facilitated speedy justice. Only we did not understand it. Even after amendments, it facilitates speedy justice. The real problem, according to me, is not following the law in true letter and spirit as found in the Civil Procedure Code. That is the cause for delay. It is the abuse of the provisions of the CPC, which is again the cause for delay in disposal of cases expeditiously. Today, if we are able to follow the CPC in letter and spirit and do not abuse the said provisions, the object of speedy disposal could be easily achieved. Therefore, the question is, who are the cause for not following the CPC and abusing the CPC? It is a case for introspection, both by the members of the bar and the bench. One of the main reasons for this sorry state of affairs is want of in-depth study and knowledge of the provisions of the Civil Procedure Code. And further, want of courage to uphold and enforce these provisions. My young friends, please bear in mind, dispensation of justice is a divine function. Judges and lawyers are equal partners in the administration of justice. If both of them realize their responsibilities and discharge their duties honestly and do not abuse the provisions of the Civil Procedure Code, it is not difficult to achieve this goal of speedy justice in this country. I am glad the Karnataka Bar Council has realized this fact and embarked upon this ambitious project like the present one to empower, to educate, and to train the young advocates in the niceties of this procedural law, and thus discharging the onerous responsibility of assisting in speedy justice to the needy litigants, a solemn duty which they are discharging. Now, everyone wants change. Lawyers, judges, litigants, and the general public wants change. Very big lectures are delivered from the position of power, office, about the need for change in our present legal system. The question is, how is it possible? Who is going to bell the cat? Who is going to bell the cat? Mahatma Gandhi said, if you want to change the world, begin by changing yourself. Your actions will then set an example and inspire the change you wish to see. Now, my question to all of you is, do you have the courage to change? And I believe that you have the courage. Future is yours. If you mind, certainly you can change the present scenario. In this context, let me remind you that one of the fundamental duties enshrined in our Constitution, that is Article 51A(j), is to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endeavor and achievement. So it is in this context. What is the position of an advocate, a lawyer in the judicial system to bring about a change, and can he do it? Here, let me remind the youngsters about the system, the role of a lawyer in the system, and the administration of justice. It is not exclusively the prerogative of a judge. The cardinal principle which determines the privileges and responsibilities of advocate in relation to the court is that he is an officer of the court, justice, and a friend of the court. This is the primary position. A conduct, therefore, which is unworthy of him as an officer of justice cannot be justified by stating that he did this as the agent of his client. So this is my first suggestion to you. Arguments are canvassed when you enter the bar. You are a power of attorney holder of a client. You have to do everything within your command to do to protect the interests of a client. And whatever you do for your client is excused. It would be a misconception, it's a misunderstanding of the role of a lawyer. No doubt you represent a client, but you also owe a duty to a court. You owe a duty to the society also. And you are a part of administration justice. You cannot go on doing whatever you want just because the client pays you and because you are representing a client. Please bear this distinction in mind. This legal profession is a solemn and serious occupation. It is a noble calling, and all those who belong to it are its honorable members. That's why you are respected in the society. Unfortunately, today we are not commanding that respect. Don't blame the society. We must have an introspection. Are we conducting ourselves in such a manner so that the society respects us? The legal profession is different from other professions. Don't compare it to other professions. In that, what the lawyers do affects not only an individual, but the administration of justice, which is the foundation of the civilized society. We are talking about democracy. We are talking about rule of law. We are talking about constitutional law. A lawyer has a very important role in this. And therefore, don't compare yourself to another profession. It is not mere money making. It is not mere getting name. You have a greater responsibility of seeing that the administration of justice is done in a proper manner and sanity is preserved in this civilized society. Both the bench and the bar are equipments of the same machinery designed for the administration of justice. You are two parts of the machinery. They are born and bred in the same nursery and have common ideals and traditions. Both are equally necessary in a free country. A judge doesn't come from above. Yesterday I was a member of the bar. He was a law student. He entered the profession. He worked in the chambers of some lawyer. Either he took an examination and got into the courts, or after serving for quite some time, he's picked up to the higher judiciary. He is basically a lawyer turned judge. Therefore, there is no question of superiority. Both are equally important. The first duty of an advocate and judges owe to each other is mutual cooperation. That is what is missing today. That is a fundamental necessity. You can't be a warring faction. You can't go on fighting the judge, and nor a judge cannot pounce on lawyers. Without it, there can be no orderly administration of justice. That mutual respect, give and take, cooperation, a friendly atmosphere. That is the essence of administration of justice. It can't be a battlefield. Advocates share with judges the function that all controversies shall be settled in accordance with law. They are partners in the common enterprise of the administration of justice. The difference in their roles is one of division of labor only. Otherwise, they are two branches of the same profession, and neither is superior or inferior to the other. This fact is now recognized in India by the autonomy given to the bar by the Advocates Act of 1961. Judges cannot do without the help of advocates if justice is to be administered in accordance with law, and its administration is to command popular confidence. Complete monopoly is given to the advocates. Unfortunately, as the advocates did not rise to the occasion, now there's a trend to allow others to also plead before the courts and tribunals. It's very unfortunate, but well, even now it is not too late for the advocates to open their eyes and make amends to the mistakes which they have crept in and still command the very same respect. Let me be very clear. The casualness and indifference which some members practice the profession are certainly not calculated to achieve that purpose or to enhance the prestige either of the profession or the institution they are serving. If people lose confidence in the profession on account of the deviant ways of some of the members, it is not only the profession which will suffer, but also the administration of justice as a whole. Please bear this in mind. Please bear this in mind. If an advocate or a judge do not conduct himself, it is not a mere mistake of his, he will indirectly affect the administration of justice, and the confidence of the people in the administration of justice would be seriously affected. So it is in this background. It is in this background. Now let us try to understand the procedural law of the land dealing with civil matters. That is the Code of Civil Procedure 1908. As I said, this is the legislation which is under attack from all quarters. But I should say it has withstood all these attacks and the test of time because of its merit. Civil procedure in India, we have on the civil side the Civil Procedure Code, which is the procedural law of the land. On the criminal side, it is the Criminal Procedure Code, which is the procedural law governing criminal courts. Now we are concerned about civil courts. So this is the procedural law of the land, which has been followed in this country for more than a century. It is not that 1908. This object of the code is to consolidate and amend the laws relating to the procedure of the courts of civil judicature. The procedure is mere machinery, and its object is to facilitate and not to obstruct the administrative justice as others accuse it of. And the Civil Procedure Code is a complete code. It provides for initiation of procedures and all procedures ending to its resolution by a judicial pronouncement. Once proceedings are initiated under the code applies to all proceedings in a court of civil judicature. Now, Section 2 of the Civil Procedure Code defines certain words used in the code. We will deal with that as and when it comes. Now, as young advocates, when we are talking about Civil Procedure Code, what you have to bear in mind is, when a litigant walks to your chambers with a problem, you have to patiently hear him and then write down what is his legal right, which is infringed, and what is the remedy to which he is entitled to. The first thing that comes to your mind is, in which court you should approach for relief. Which is the court which is competent to grant the relief. The reason why I am saying this is, take for example the Bangalore. In Bangalore, both two district courts, that is Bangalore City and Bangalore Rural courts are there. As far as city courts are concerned, we have what is called as Bangalore City Civil Courts Act, where a particular hierarchy of courts are there. All district judges are designated as city civil courts, and you have small causes courts dealing with small causes cases. In the same building, you have the Bangalore Rural Courts, Bangalore District Courts. There you have a principal district judge. There you have city civil judge senior division. Then you have civil judge junior division. Then you have magistrate courts. You have Karnataka Appellate Tribunal near the High Court. And in the district level, the same pattern is there, except for Bangalore City Civil Courts. The question is, when a person comes with a problem and you are convinced that he has a legal right, the question is, to which court you have to go. If you go to a wrong court, it will be a reflection on your competence. The first and the foremost thing a lawyer should decide is, in which court I am going to institute a legal proceedings. So Civil Procedure Code exhaustively deals with this. Section 9 of the Civil Procedure Code speaks about jurisdiction of courts. Section 9 says, courts to try all civil suits unless barred. Now we have to mark the words courts. So every court has the jurisdiction to try a civil matter unless it is barred. Unless it is barred. This is what was said in 1908, when probably we had only three courts: the civil court, a criminal court, and a revenue court. So in 1908 itself, this legislation said, the court shall have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is either expressly or impliedly barred. So therefore, sky is the limit. The test is, what is the nature of suit? Is it a civil suit? The court has jurisdiction, unless it is expressly or by necessary implication barred. This is a principle which a lawyer should know. When we say so many civil courts, in which court you are going to find it? If it is a criminal court, magistrate court. And if it is not a civil case, which is the other court, which is expressly or by necessary implication barred? Here, you see the way the section is worded. The section has a positive as well as a negative aspect. The positive aspect is to be found in the earlier part, which opens the door widely. That is, by entitling civil courts to entertain all suits of civil nature. Wide enough, sky is the limit. But the negative aspect is, it bars the entry of suits only if there is an express or implied bar. So therefore, it's a question of jurisdiction. If a person wants to say this court has no jurisdiction, then it is for him to show why that court has no jurisdiction. This jurisdiction is a very important aspect in the civil law. Please understand, this jurisdiction aspect is not something which you can treat it lightly. If you don't have jurisdiction, the court has no jurisdiction, it cannot entertain the suit. It cannot conduct a trial. It cannot decide. Even if it decides, it has no value. Therefore, over the years, certain principles have evolved on the civil side, which you don't find it in the Civil Procedure Code, but It has the force of law. What is that? The fundamental principles which a civil lawyer should bear in mind while dealing with a civil dispute is this. If a court has no jurisdiction to entertain a suit, and if it entertains a suit and decides the case, the judgment and decree or order passed by the court which has no jurisdiction is void ab initio. It is a nullity. It is not worth on the paper in which it is written. The entire exercise will be an exercise in futility. You don't get it in CPC, but this is a well-established principle of law, which a lawyer should bear in mind. Therefore, entire effort should be there at the earliest point of time to find out for yourself the court to which you are going has the jurisdiction to entertain the suit. It may be a civil court, but that court has the jurisdiction to decide it. Is there an express bar? Is there an implied bar? This is an exercise that lawyers should know. Client does not know. He has come to you. He has given you the problem. He pays you the money and you go by your advice. Then another important principle which a civil practitioner should bear in mind is the jurisdiction on a court is conferred by a statute. If you have to say that court has jurisdiction, it is a statute which says it. If the statute is not conferring jurisdiction, there is no other mode of conferring jurisdiction. In fact, a leading case on this, maybe on the criminal side, was the Antules case. The matter went up to Supreme Court. The Supreme Court said, all right, let the High Court decide this matter expeditiously because a matter of public importance. They decided it. Then again, it was taken to the Supreme Court and said that court had no jurisdiction. And the Supreme Court had no jurisdiction to confer jurisdiction on a court which had no jurisdiction. And the Supreme Court accepted it. So therefore, the jurisdiction of a court is determined by a statute and not by any other persons. And therefore, you have to find out which is the statute which confers jurisdiction. And once, because of this importance of jurisdiction, it is well settled. Whenever a dispute arises regarding jurisdiction, they have to be decided at the threshold as a preliminary point. Otherwise, it is of no use. In the end of the day, after trial, if you are to hold that the court has no jurisdiction, it is of no use. Therefore, it is settled law. Wherever a question of jurisdiction is raised, it shall be tried as a preliminary point, and only if the court has jurisdiction, the trial will go on. Now, this question of jurisdiction can be raised at any stage of the proceedings, including appeal, second appeal, and in revision, and also on the execution side. That is the importance of jurisdiction. Jurisdiction of a civil court. If the court has no jurisdiction, if it has passed a decree and award, and even if the trial court objection is not raised, it will be raised in appeal, revision, execution side, and say this decree is inexecutable. It is void ab initio. It is not enforceable. Having said this, who has to decide the question of jurisdiction? It is also well settled. Even if the court has no jurisdiction to decide the case on merits, if an objection regarding jurisdiction is taken at the earliest point of time, the question of jurisdiction is to be gone into the same court. Though it has no jurisdiction to go into the merits, it has jurisdiction to decide whether it has jurisdiction or not to go into the case. No other court will decide it. No other court can decide the question of jurisdiction of this court. The very court where the matter is pending, if it is contended that court has no jurisdiction, that court has to decide the question of jurisdiction, and it has jurisdiction to decide whether it has jurisdiction to go into the matter or not. And lastly, this jurisdiction of a court cannot be conferred by consent of parties. Even if parties consent, agree, if that court has no jurisdiction, any decree passed by that court will have no value. Therefore, it is well settled, parties by consent cannot confer jurisdiction. These are some of the fundamental principles of civil law which a lawyer should remember when a litigant walks into your office, discuss with him, and when you decide to file a suit, therefore you must be clear in which court it has to be filed. Then another aspect of this jurisdiction is what is known as a pecuniary jurisdiction, then what is known as territorial jurisdiction, then about the maintainability issue. Now, when I talk about pecuniary jurisdiction, in Karnataka, we have what is known as Karnataka Civil Courts Act. It talks about the various courts and their pecuniary jurisdiction to decide. To give an example, now we have, earlier we called it as Municipal Court, then we called it as Civil Judge Junior Division, today we call it as Civil Judges. That is a court which has jurisdiction to decide matters, the value of which is less than 5 lakhs. Above 5 lakhs and unlimited civil judges, senior division. It's called a pecuniary jurisdiction. So it is a civil court. The dispute is also a civil dispute, but that particular court should have the jurisdiction to decide the suit depending upon the monetary value. Pecuniary jurisdiction is called pecuniary jurisdiction. Similarly, we have what is called as territorial jurisdiction. As I said, in Karnataka, we have 30 districts, about 187 taluks. In some hoblis also, we have constituted courts. Why do we need so many courts? These courts have a particular territorial jurisdiction. Disputes arising within those territorial jurisdiction are cognizable by this court. If that dispute arises at a place adjoining that court has no jurisdiction. So it's a question of arrangement. But again, it's a question of jurisdiction. The third category is, it has nothing to do with pecuniary or territorial jurisdiction, whether the court has the jurisdiction to decide. That is about the maintainability of the suit. So therefore, when you have to decide which is the court, in your thought process, you must be very clear. The court to which you want to go, does it have the pecuniary jurisdiction? Does it have a territorial jurisdiction? Is the suit maintainable? So merely because it is a civil suit and you are going to the civil court, that will not solve the problem. Though the section is so simply worded, saying all civil suits of civil nature are cognizable by civil courts. It is not just simple. That's where we commit a mistake. Merely because some court is nearer to you, you can't go and file it. So these are all the aspects which a civil lawyer should bear in mind and should, at the earliest point of time in his career, master this. Once this is done, then it will be easier for him to make progress. Now, when I am talking about classes of suits, civil laws, they can be divided into 2 types of suits. Civil suits itself could be about 2 suits. Those are of civil nature and those for the purpose of Section 9, which is of civil nature. The reason is, though in 1908 we did not have this problem, over the years, the problems multiply. Now, for example, it is understandable if it is a criminal case, as opposed to civil case. Among the civil suits, you have disputes dealing with laborers, which are cognizable by labor courts. It's a civil dispute only. A taxation dispute is a civil dispute. A service matter is a civil dispute. A revenue matter is a civil dispute. Now we have got debt recovery tribunals, purely civil matter. Then we have the land reforms tribunal dealing with civil matters, tenancy rights in respect of lands. Then we have got cooperative courts dealing with money matters, dealing with property matters, again a civil matters. And recently we have got Green Tribunal, the Company Law Tribunal. They are adding. These are all civil disputes. But a civil court has no jurisdiction to go into it. Why? Their jurisdiction is expressly or by necessary implication barred. So even though it is of a civil nature, even though civil courts under Section 9 of the Civil Procedure Code have jurisdiction to retain it, these all fall under the category of bar of jurisdiction expressly or by necessary implication. Therefore, when you want to file a suit, you must have a clear picture about the nature of the suit, whether those suits are covered under various enactments, whether civil court jurisdiction to entertain the suit is barred expressly or by necessary implication. Now, what do you mean by a suit of civil nature? A suit is of a civil nature if the principal question therein relates to a civil or a legal right. To put it simply, that is the position. Now, Section 9 has two explanations. The principal or only question in a suit is a caste question or a question relating to religious rites of ceremonies. The suit is not of civil nature, but it deals not the rights of the citizen, but with matters that are purely social. Therefore, frequently this problem arises in civil courts. Declaration that he belongs to a particular caste because that declaration gives him so many rights, constitutional rights. So, to which caste he belongs is purely a civil nature. But today, their jurisdiction is boosted by constituting authorities to decide these offices. Similarly, office. Basically, this office dealt with was a hereditary office of an archek. It was a religious office. We are a secular country. Now, question is whether the civil courts can go into this. Therefore, no explanation is added by saying yes. Those questions also can be gone into by the civil courts. It is immaterial whether any remuneration attached to the office or not, but it is a civil dispute, whether he is an archek, whether it's a hereditary archek, whether he is holding a particular post in a temple or a religious denomination, and those matters can be gone into by the civil court. That is by explanation. There is no difficulty about that. Now the difficulty is about the suits which are expressly barred. As I said, because the civil courts, according to the critics, did not deal with the matters expeditiously, and the problems became numerous. In our country, in the last probably 30-40 years, we have what is known as creation of tribunals and alternative mode of resolutions. So therefore, whenever a legal right is claimed and it is infringed, a cause of action arises to that person to approach a court. In the normal course, he should have approached a civil court for resolution of the dispute. But today, several forums are constituted to go into these questions. And expressly, the civil court jurisdiction is taken. The earliest point of time is the Karnataka Court Societies Act of 1959. Section 118 of that act says, specifically bar of jurisdiction of courts. They thought we are going to usher in a new era in this country by cooperative movement, and disputes arising in cooperative movement, if we have got to civil court, there will be no end to it, no resolution, and the cooperative movement will pay. And therefore, Section 118 said, bar of jurisdiction of courts. Save as provided in this act, no civil, labor, or revenue court, or industrial tribunal, these are amendments, shall have any jurisdiction in respect of several matters which are enumerated therein. And Section 70 provided for a mechanism to resolve those disputes. That is how expressly the civil court jurisdiction is taken away in respect of disputes arising under the Karnataka Court Societies Act, that dispute though being purely of a civil nature. Then came the Karnataka Land Reforms Act of 1961. Again, it dealt with bar of jurisdiction because till such time, tenancy rights, they thought if it is given to the civil courts, there won't be any end. And therefore, they came up with the Section 132. No civil court shall have jurisdiction to settle, decide, or deal with any question which is by or under this act required to be settled, decided, or dealt with by the Deputy Commissioner, an officer authorized under subsection 1 of 77, Assistant Commissioner, the prescribed authority under Section 83, the tribunal, the Tahsildar, the Karnataka Appellate Tribunal, or the state government in excess of the power. So, civil court jurisdiction is taken away. This is the most unfortunate thing. As lawyers, as I said, as responsible lawyers, as part of the administrative justice, please go through each one of these acts. Don't blame the court. You are also a part of administrative justice. If there's a blame on the court, equally the blame should be on the members of the bar. See the way in which powers are given to the deputy commissioner, the assistant commissioner, taking away from the jurisdiction. But this is history and hard fact of life which we have to accept. Then we have the Karnataka Land Revenue Act. Section 61 says exclusive jurisdiction of revenue courts and bar of jurisdiction of civil court. Revenue matters are quite big. Today everybody wants land. All disputes concerning land today is not within the jurisdiction of civil courts. It is being taken away by the revenue courts. Only regarding title to the property, if there's a dispute, civil court has got jurisdiction. In all other matters concerning agricultural land or a non-agricultural land, it is the revenue courts which are going to decide those disputes. Then we have the Karnataka Public Premises Eviction of Unauthorized Occupants Act of 1974. It was a nightmare to evict a tenant under the Transfer of Property Act through a civil court was a nightmare. And the premises which are affected were the public premises. Therefore, legislature passed an enactment taking away the jurisdiction of the civil court and conferred jurisdiction on what is called as an estate officer. Then recently we have the Panchayat Act 1983, which clearly says civil courts have no jurisdiction to decide the disputes arising. The latest was the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. Section 34 specifically said civil courts have no jurisdiction. In fact, whenever even the High Court entertaining matters under Article 226, Supreme Court has come down heavily criticizing the High Court, saying, why the hell are you interfering in this? Neither the High Court nor the Civil Court has jurisdiction to entertain these matters. These are all special legislations. Public money is involved. Huge money is in default. It has to be recovered. Maybe the provisions are draconian. It can't be held. Therefore, civil court jurisdiction is completely ousted from this. And we have also the Right to Information Act of 2005. Then we have Karnataka Municipalities Act. Then we have Karnataka Small Causes Courts Act, which deals exclusively with certain cases and over which Supreme Court, the Civil Court has no jurisdiction. Take, for example, the Indian Partnership Act of 1932. They put it in a different fashion. If a partnership firm wants to enforce a contractual obligation through a civil court is the only forum. But the condition precedent is that partnership firm should have been registered. If partnership firm is not registered, court jurisdiction is taken away. And courts have to dismiss the suits on the ground of want of registration. Then we have this latest Karnataka Transparency in Public Procurement Act, where completely in these tender matters, civil court's jurisdiction is taken away. Then we have the Karnataka Municipalities Act of 1964, where also the jurisdiction of the civil courts have been taken away. So what I am trying to say is, see the Section 9 as drafted in 1908. So much confidence in the civil courts. All civil suits of civil nature, the court will have jurisdiction. That is the domain of the civil court. Probably, if the civil courts had functioned properly, as stipulated in the Civil Procedure Code, this position would not have come. It should be an eye-opener to the bench and the bar. It is a clear case of no confidence in the bench and the bar by the parliament. So many enactments. And in every enactment, they have taken away the jurisdiction of civil courts. And they say, whether those forums have delivered the goods is a different question. And in many cases, it is only the very same judges who will be there also. But the way in which the civil court jurisdiction is boosted expressly by the parliament or the state legislature should tell the members of the bar and the bench a case for introspection. At least know it should halt. So this is about express bar of a civil court jurisdiction to deal with a civil dispute. Now, in addition to that, we have what is called as implied bar. That's the section. See how beautifully it is drafted in 1908. What a foresight. So what do you mean by implied bar? No act says civil court has no jurisdiction. How do you decide it is impliedly bar? If you look into the case law, it will tell you when a particular right is conferred on a citizen by a particular enactment, if that particular enactment provides for a comprehensive machinery to work out that remedy, to work out that right, the existence of a comprehensive machinery to resolve the dispute excludes the jurisdiction of civil courts. Though expressly in those cases it is not stated, the creation of a comprehensive machinery to resolve the dispute excludes the jurisdiction of civil courts. In addition to that, you see, we have some examples. For example, take the Land Acquisition Act. Land Acquisition Act does not exclude the jurisdiction of civil courts. But what happened was, the land acquisition is in two portions. One is acquisition of land. Another is payment of compensation. Now, acquisition of land has to be done in accordance with law. The law provides for it. Constitution provides for it. You can acquire the land in a manner known to law. Pay compensation. But if the acquisition is not done in accordance with law, say a violation of principles of natural justice, a mandatory provision is not followed, then what is the remedy? The Act says, if a land is required for public purpose, a preliminary notification has to be issued, call for objections, consider the objections, then overrule the objections or uphold the objections, issue a final notification, then issue notice, conduct, pass and over. Now, if these notifications are not in accordance with law, purpose is not a public purpose, it could be challenged. It's purely a civil matter. So therefore, in the past, the challenge to the acquisition was there by way of a writ petition to the High Court. They also challenged the acquisition in the civil court, saying it is not a public purpose, notification is not in accordance with law, particulars are not furnished, so many things. Sometimes it so happened after losing the battle in the High Court, a fresh litigation commenced in the civil court. Therefore, the Supreme Court, by virtue of its power under Article 141, about 20 years back, declared as what? Insofar as challenge to acquisition is concerned, civil courts have no jurisdiction at the time. The party has to uphold the civil court. There is no law. Acquisition Act doesn't say so. It is what the Supreme Court says so by way of a judgment. An article under Article 141. Today, therefore, if you are challenging an acquisition, you cannot do so in a civil court. Having said this, please see the other aspect of it. If you don't have clear notions, if the acquisition is done under the Act, whether it is legal, valid or not, that can't be challenged in a civil court. It has to be challenged in the High Court. But without acquisition, if the land is sought to be taken, then the owner is deprived of his valuable right to property. Though it's not a fundamental right, it continues to be a constitutional right. What will the High Court do? There's nothing High Court can do. So it is only the civil court which has to decide whether the land is taken through acquisition or without acquisition. If without acquisition, civil court alone has the jurisdiction to grant an injunction. So this is an aspect which you must bear in mind. CPC is all right. Judgments are all right. These are all intermediary things which has happened over a period of time by way of judgments of the Supreme Court. For some time, Industrial Disputes Act also, we have an Industrial Disputes Act where a dispute arises, conciliation fails, matter is referred to a labor court, things go on. The termination was also challenged in the civil courts on the ground of principles of natural justice. Now the Supreme Court says, no. If it is an industrial dispute, it is only the courts constituted under the Industrial Disputes Act which has to decide it. Civil courts have no jurisdiction. It is by a pronouncement of the Supreme Court, a judgment under Article 141 of the Constitution. Now we have what is called as rent control matters. They are purely a civil matter. Landlord and tenant, termination of tenancy, recovery of possession. In order to give protection to poor tenants, earlier they passed what is called as Karnataka Rent Control Act. Now that is repeated, and now they have passed Karnataka Rent Act. So in order to give protection to those poor tenants, a special enactment is made. Of course, there are certain prescriptions, either the rent or the extent of land. If it is more, it is the civil code. If it is within that, it is the rent control code. The law is the same. So therefore, here also, there is no express bar. By enacting a particular legislation with the intention of protecting tenants and providing a comprehensive machinery for eviction of those tenants under that, the civil court's jurisdiction is boosted. That is a case of implied booster. Similarly, in the case of date of birth also, for government servant is an enactment, for a private individual is the civil court. So therefore, it is also a case of implied bar to the jurisdiction of the court. Therefore, in civil law, this jurisdiction aspect is a very, very important aspect which a civil lawyer should bear in mind. This is the first step you are going to make in the course of a litigation. A sound knowledge of the jurisdiction and the various facets which I explained to you will give you the confidence. Because if you commit a mistake and if some court throws it away saying that I have no jurisdiction, it reflects, what will you tell the client? He thought you know the law, he came to you, he paid the fee, and you will go to a wrong court and the court says I have no jurisdiction, go somewhere else. Very difficult for you to explain to me. Therefore, it is not a simple matter. So a thorough, in-depth knowledge, understanding of Section 9, what do you mean by a civil suit? What do you mean by express bar? What do you mean by implied bar? What are the circumstances which are now added by judgments of Supreme Court? A thorough knowledge of which is a must for a civil court lawyer to keep the first step in the civil litigation. So today, I'll stop it here. Let me have any questions.
Thank you, sir. Thank you for enlightening us and for your valuable inputs. I now request Professor Dr. V. Sudesh to take over the question and answer session. Over to you, Sudesh, sir.
Thank you, sir. Thank you, sir. I don't think it will be improper for me to say that we have begun with Deepavali celebrations very early. Deepavali yakandre sir presentation ತುಂಬಾ ವಿಷಯದ ಬಗ್ಗೆ ಬೆಳಕು ಚೆಲ್ಲಿದೆ ಆ ರೀತಿ ಒಂದು ದೀಪಾವಳಿ ಇನ್ನೊಂದು ಸರ್ the presentation was like a burning of a cracker and non-stop for exactly 1 hour. It was fantastic, covering the most important aspects of civil procedure codes. I have some basic questions. ಇಲ್ಲಿ ಒಬ್ರು ಕೇಳ್ತಾರೆ ಅದೇ ಪ್ರತಿ ಲಾ ಸ್ಟೂಡೆಂಟ್ ಮತ್ತೆ ಬಿಗಿನರ್ ಲಾಯರ್ಸ್ ಗೆ ಕನ್ಫ್ಯೂಷನ್ ಇದ್ದೇ ಇರುತ್ತೆ ನಮಗೂ ಇತ್ತು ಕಾಲೇಜಲ್ಲಿ ಓದ್ಬೇಕಾದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಡಿಫರೆನ್ಸ್ ಬಿಟ್ವೀನ್ ಸೆಕ್ಷನ್ಸ್ ಆರ್ಡರ್ಸ್ ರೂಲ್ಸ್ ಅಂಡ್ whether there can be 2 degrees in one suit.
Section is a substantive provision and orders and rules give effect to that with minute particulars. An order and a rule should be consistent with the section. If it is not in section will prevail and not the order and the rules. What is the second question you said?
Whether there can be 2 degrees in one suit.
Civil procedure code do not provide for 2 degrees in a civil code. But there's a judgment of the Supreme Court which says, in the case of partition suits, if an event has transpired after a preliminary decree is passed, instead of asking the parties to re-agitate over again, there could be a second preliminary decree. CPC doesn't say it, judgment of the court says it, and thus the law declared by the Supreme Court under Article 141. And it is confined only and only to partition suits. That is, a preliminary decree is passed declaring plaintiff and defendants are entitled to 1/4 share. Who are the plaintiff and defendant? Son, daughters, and mother. After the preliminary decree, before final decree, if mother dies, intestate, her right devolves on the remaining persons. The question is, are they expected to file one more suit? The answer is no. Her share, when it devolves on them, their 1/4 share becomes 1/3 share. To that effect, one more decree could be passed. Say, in view of the subsequent event, the death of the mother, when the rights have devolved on others, instead of 1/4, the share is 1/3 share. Therefore, there could be 2 decrees, 2 preliminary decrees in a partition suit, though it is not specifically. What the Supreme Court says is, civil procedure code do not bar, that's how they put it. It does not bar passing of another decree.
Yes, thank you, sir. Second question is, of course, this is related to role of lawyers and judges and courts, etc. They say that justice delayed is justice denied. Sir, what is your opinion in the context of the procedures in the CPC?
That's precisely the reason why I have taken pains to address the members of the bar. Everybody is blaming the CPC as if CPC is the villain. If you understand CPC, obey the CPC, there won't be any delay. It is because the lawyers and judges have no respect for CPC, respect for law. The delay is occurring. Yes, justice delayed is justice denied. There's no doubt about it. CPC is not the cause. People who are expected to administer justice, the lawyers and the judges, they do not know principles underlying these principles, and they are the cause for delay, and don't blame the CPC. My entire effort in these 11 lectures would be before. CPC is not the cause. It is the person who is driving the vehicle is the cause. The vehicle is very good, machine is very good, tank is full of petrol. If you don't know how to drive the vehicle, don't blame the vehicle.
Thank you, sir. Third question is, if a court passes an order without jurisdiction, of course, as you said, the order is void and nullity. But the question is whether a revenue officer can say the order of the court is void and there is no sanctity and therefore he will not implement the court order. Secondly, whether the party needs to get another order to set aside the said nullity order which is passed without jurisdiction.
An order without jurisdiction is a nullity, non-est in the eye of law. Therefore, that objection could be raised at any stage of the proceedings, in appeal, in revision, and on the execution side. That's the law. So, if a revenue officer refuses to obey a civil court decree on the ground that it is a nullity, certainly you will try to hold him for contempt. And in the contempt proceedings, he is able to demonstrate, yes, this is a nullity, and the court accepts it. That's the end of the matter.
Thank you, sir. Innೊಂದು ಪ್ರಶ್ನೆ ಇದೆ. This is with regard to territorial jurisdiction. If a property for partition is situated in 3 different districts, which court will have the jurisdiction? Where early case file ಮಾಡೋದು ಅಂತ ಪ್ರಶ್ನೆ.
All the 3 courts will have jurisdiction. All the 3 courts where the property is situated, you can choose and you can file. All the 3 courts will have jurisdiction. If you file a suit in one court where one property is situated, you can add the property situated in another 2 courts also hearing, and you can file a suit. There's a specific section in the Civil Procedure Code providing for that. I will deal with that either tomorrow or day after.
Thank you, sir. This is again a question by a law student in the context of the role of lawyers in dispensation of justice. He says, why litigants are not heard before passing an order on a given hearing date? Mere giving wakalats to an advocate, does it mean that litigant has lost all his rights to speak in the open court?
Yes. Party has the right to appear in person and make his submission. Once he entrusts a matter to a lawyer by executing a wakalat, you cannot have 2 voices, only one voice. Either the lawyer should speak or the client should speak. You withdraw the wakalat and you are beneficial.
Thank you, sir. I don't know whether we have to address this question right now, sir, because we have not discussed this. Question is, can soon after a preliminary decree, whether a decree holder can execute a testamentary document without FDPs?
See, it will be hit by doctrine of dispendence. He can do, there's no prohibition for it. In the end of the day, if he succeeds, that will have value. If he loses, it has no value. It is dispendence. And more than that, testamentary document will come into force only after his death. So mere execution of testamentary document will not create any right in any process.
Time for one last question, sir. Can you comment on the role of the scrutiny branch in putting up the civil case filed intentionally in the wrong jurisdictional court, and also the diligence of the PO in passing of the ex parte interim injunction order?
We'll come to that. We are still in the stage of jurisdiction. We'll come to that.
Okay, thank you, sir. Pardon me, dear friends. I've only asked those questions which were relevant for today's discussion. So other questions can be asked in course of time. Sir, one question was a person wanted to know the citation of the criminal case with regard to jurisdiction, finality of jurisdiction. Sir, a citation the case is note the criminal case.
Wherever I deliver a lecture, I don't give them citation. It is the job of the student to go and sit in the library.
Thank you, sir. Okay, thank you so much, sir. Just to, sir, 3 points to take away from today's presentation. Sir has said access to justice and speedy trial are fundamental rights. dispensation of justice is a divine function, and mutual respect between lawyers and judges will go a long way in affording access to justice. And finally, CPC 1908 is still very good law despite all the amendments and criticism. Thank you so much. Over to you, Varsha.
I consider it my pleasure to thank Hon'ble Justice N.Kumar for answering the questions patiently. I also extend my thanks to Professor Dr. V. Sudesh. Now I request Sri Gautam Chand SF, President of Karnataka State Bar Council Law Academy, to deliver the vote of thanks. Over to you, sir.
Respected Honorable Justice N.Kumar, all advocates, law students, senior counsels, Bar Council members, Bar Council Chairman, Bar Council of India member, and all other dignitaries. In fact, if I may say, I may not be wrong, a new history has been written with the help of Justice N.Kumar in the history of Karnataka State Bar Council. It was really, though I have been practicing for more than 30 years, the kind of dimensions which you have given to just territorial jurisdiction and the concept of jurisdiction is really mind-boggling. And in fact, you would have spoken on this subject if the time would have permitted you for another 2-3 hours. And I had become a student, sir. I had become a student. I was making notes. You have enlightened not only the young minds, but also the advocates who have practiced for more than 10 to 20 years. It was an excellent and amazing experience for each and every participant, sir. Really, for on behalf of Karnataka State Bar Council and on behalf of Karnataka State Bar Council Law Academy, I express a sense of gratitude, and we shall always remain indebted to you for accepting our invitation and delivering this initial lecture. And I know you will continue this for the coming 9-10 days. Sir, we are very grateful to you. Thank you so much. Thank you so much, sir. Now, I thank all the participants, advocates, senior counsels, our own chairman, vice chairman, trustees of the Law Academy, law students, professor, and specifically Professor Sudesh, who has taken out some time and made the function and this question and answer session very simple and attractive. Thank you. Thank you, one and all. Thank you very much. Now, I think, is there anything? We will conclude this session, and then with justice, we will discuss informally some other aspects with respect to other tomorrow's event and subject. Therefore, now I conclude this and declare that session is concluded.
About
Thank you.
tomorrow's
Thank you
program.
very much.